So today we're going to go over what is a 341 hearing in bankruptcy. People often hear about this when they're thinking about filing bankruptcy. They hear about a creditor's meeting or a 341 hearing. So those are held in every bankruptcy case for individuals. So I'm going to go over just some of the basics of them, how to prepare for it, and some of the common questions or things that are going to happen. Now, this is informational only. It might not apply to your case, and this is based on where I practice in the Central District of California. So each district, federal district, could be a little different in exactly how they do this, but it is based on federal law, so it should be pretty uniform depending on where you're located. What is a 341 hearing? A 341 hearing, it's not actually technically a hearing in front of a judge in court. It's more of an informal creditors meeting, and it's a meeting with a bankruptcy trustee, who's someone who is appointed to oversee your case. It's required in every single case that you file, whether it's a Chapter 7 or a 13 or even an 11, and it's an informal creditors meeting. Technically, it serves a couple purposes. It's to give creditors an opportunity to ask you questions about your assets and your debts, and also for the trustee who's assigned to your case to ask you questions as well. Now, the trustee is typically a private attorney, a local attorney that's experienced in bankruptcy, that's assigned by the court to oversee your case. Usually they will appoint them immediately after the case is filed, and so you'll know who the trustee is going to be. How do you prepare for a 341 meeting? Well, you're going to get notice of the 341 meeting as soon as you file your bankruptcy case. They typically schedule about 30 to 45 days out from the date that you file for your 341 to take place. They'll give you the location, the date, and the time, and that's going to be provided in writing by a notice from the court to you, also to your attorney if you have an attorney in your case. And it also goes out to all creditors to give them notice of the creditors meeting. During the pandemic, the creditors meetings have been held by Zoom video conference or by phone, although in the past and probably in the future, they are held in person at the local bankruptcy court, usually in a meeting room. And you're gathered there with, it could be 10 to 50 other people, all scheduled around the same time frame in like a 1 hour block. So there's going to be a lot of other people either on the Zoom conference call or in person. And when you're getting ready for the 341 meeting, it's a pretty informal meeting, so it's nothing to get too stressed about. However, you should have a copy of your petition and schedules, and those are the documents that you filed when you filed your case. So you have those reviewed and with you for the hearing. Now, if you're doing the 341 meeting by phone or by video, be sure, very sure, to have it somewhere where there's no background noise and you have a copy of your petition and schedules with you, and you're not driving or doing anything else at the time, because the trustee may not hear your case if there's distractions like that, because there's so many other cases that need to take place. Having the schedules and petition with you is going to help to make sure you can answer their questions. They might ask you specific questions about something, how you listed an asset in your schedules. So you want to be able to refer to whatever page they're talking about. Prior to the 341, they're going to ask for a number of documents that either you or your attorney, if you have one, needs to provide to them prior to the hearing. And it's important that you get it in plenty of time to them, because they could continue your case to a different hearing date, or they could potentially ask the court to dismiss your case if you're not complying, because you're obligated to comply with requests of the trustee assigned to your case. They're going to ask for things like your driver's license, a social security card, or other proof of your identity and social security number, which can be provided in other forms if you don't have those documents, but those have to be provided ahead of time. They'll usually want to see your last couple of years' tax returns and possibly bank statements, statements regarding real estate or insurance. Just depends on the type of case, but they will provide a list of documents that they want to see. Make sure you get all those ahead of time, and make sure you obviously calendar the date and time, and you show up ahead of time because they have so many cases they have to deal with that they're not going to wait around if you're late. And if that happens, they might continue the meeting to another date, or they could ask the court to dismiss your case. So it's very important that you are there and you're there ahead of time, and that you've provided all the documents that they request. Some of the standard questions that are asked, and I'll put up a list of sort of the standard questions in the Central District that are asked by most trustees that are assigned to your case. When they call your case, then they're going to ask you to state your name and put you under oath. So you're going to swear under the penalty of perjury that everything you're saying is truthful. Now, this is an informal meeting, usually taking place in more of an office type setting. However, the trustee assigned to your case does represent the government. And if you're caught lying about something, you forget to list something, and you avoid it, be thinking that you don't have to list it, you have to be completely truthful in that 341 meeting, because they can refer this case to the FBI, because lying or falsifying information in a bankruptcy case is a federal crime investigated by the FBI. So it's very important that you provide all information, answer everything as truly and correctly as you can. Generally, the 341 meeting is going to be pretty quick in most cases. As long as everything looks normal in your petition and schedules, they're just going to ask you some basics about, is this your current address that you listed? Did you read and sign the petition and everything that you filed with the court? Are you familiar with the information contained in the documents? Is the information true and correct? Are there any errors or omissions? Do you need to make any changes to anything? One thing to note that I get a lot of common questions on is, well, we filed on June 1st, but I got a new job in July before the creditors meeting. Do I need to update the schedules or tell them we need to change something? Most of the time, no, you do not need to make changes. Your bankruptcy is based upon the date that you file your petition. And so when they're asking about, is everything correct? They're asking, when you file the documents, was everything correct? So generally, there's no obligation to go back in and keep updating them as things change if your expenses or income changes. There can be some exceptions to that if you get, for example, if you receive a tax refund that you should have listed as a potential asset coming in, and you get that after you filed, you need to make sure that's disclosed. Or if you obtain, you inherit something within several months after filing bankruptcy, that is something you may need to disclose. So you need to take a look at that or talk to an attorney if you have one to see if that's something you might need to disclose. They're going to ask you if you've listed everything you own, and if you're married but only one of you filed bankruptcy, you still have to list assets of both spouses. So they're going to ask to make sure you listed everything. Did you list all of your creditors, everyone that you owe money to? Have you ever filed bankruptcy before? Because there are limits on how often you can file bankruptcy. Are the tax returns that you provided true and correct? Do you have domestic support obligations? So do you owe money for child or spousal support? If so, most trustees have a separate form they're going to want you to fill out and sign ahead of time to provide to them to disclose if you have a domestic support obligation and if you're current, or if you have back owed amounts. And if the address of your employer, if any, is on there, is correct. And most trustees will ask you if you've read the bankruptcy information sheet, which is a sheet that is provided either electronically ahead of time, or if your meeting is in person. Here in the Central District, it's called a green sheet because it's printed on green paper and it's in the meeting room that you can take and look at and read through. Here's a copy, a sample. It's basically just an informational brochure about bankruptcy. And a lot of this stuff is supposed to have been disclosed if you had an attorney prior to filing, talking about what is bankruptcy, what are the different types of bankruptcy, what's a discharge, and just general information. This one's only 2 pages, so it's quick to read through, and they'll usually have it versions in English and Spanish and sometimes other languages. But they'll ask you to make sure that you've read through it so you understand the requirements of bankruptcy. And generally, unless the trustee sees something that stands out, that might request more information. So if there's an asset that they think maybe the value isn't right, you listed a car and you said it's only worth $5. Well, most cars, unless they're junk, they have some value. So they might ask you about the type of car, if they think there's a bank account that you didn't list, any kind of asset they think might not properly be represented, they're going to ask more information about. But if you've disclosed everything and been completely forthcoming, it generally takes a few minutes for the creditors meeting once your name is called, and then you're done. If there's information that they ask that you don't have, they may ask for additional documents. So they might want some bank statements or some other kind of document, and they will continue your 341 meeting to a new date, sometimes 30 days out, just depends on their schedule. And they'll ask you to provide those documents prior to the new hearing date. And then if you provide them, a lot of times they will say you don't have to appear at the next meeting because they have what they need to decide what to do with your case. Once they've received everything, then basically the case is going to go to them to make a decision on what needs to take place, whether it's a Chapter 7, Chapter 13 case. If it's a Chapter 7 and there's no assets there, there's nothing there for them to sell off, to liquidate and pay your creditors, they'll issue a report of no assets, and that's something electronically filed, usually within days after the meeting is done. And they file that with the court so that the court knows the 341 meeting is concluded. And that starts a 60-day waiting period before your discharge in a Chapter 7. After the 341, you want to make sure you've taken the second course in bankruptcy, which is the personal financial management. That can be done anytime after you file your case, but you want to make sure it's taken care of shortly after the 341 if you haven't already done it. In a Chapter 7, once you do that, then you're done. You have to wait for your discharge to take place, and an order will be issued by the court of your discharge that you'll get in the mail. If it's a Chapter 13, you have to attend, unless your attorney or someone tells you you don't have to attend, a confirmation hearing before a judge to see if your Chapter 13 plan will be confirmed and provide any kind of documents or possibly the first payment under the 13 plan. So that's something that takes place after the 341, and the confirmation hearing will be scheduled after the 341, and it's usually scheduled right when you file your case. So that's the basics of the 341. It's a pretty informal process, but you do need to still take it seriously and make sure you comply. If you don't show up, they might continue it at least once to make sure you show up. If you don't show up or you don't comply with what the trustee is asking you, because you have to, as they represent the court, then they could request that the court dismiss your case, possibly with a bar on refiling, which means depending on what they ask for, if you didn't comply, then they could dismiss your case and say that you cannot file again for example, 6 months or some period of time. And so if you made a mistake and forgot to show up and your case gets dismissed, you may not be able to just refile it right away. You might have to wait. So that's something to be concerned about. But that's about it for the 341 meeting.